Good afternoon, and welcome to the New Civil Liberties Alliance and today's Lunch and Law program called Unforgivable Student Loan Forgiveness. I'm Russ Ryan. I'm a senior litigation counsel here at NCLA, and today we're going to be discussing the Biden administration's plan to cancel nearly $500 billion in outstanding student loans that are held by some 40 million borrowers. With us today, we have a great panel here, two experts on this topic. First is my colleague Sheng Li. He's a litigation counsel here at NCLA. Before that, he was an attorney with the Department of Labor, and before that with two prominent law firms. Also with us is Neil McCluskey. He's the director of the Center for Educational Freedom at Cato Institute. He's the author of a book called The Fractured School, Re-Examining Education for a Free, Equal, and Harmonious Society. And he's co-edited several other books. He's also a prolific writer and speaker in this area of education policy and in particular school choice issues. So we're delighted to have you here today, Neil.
Thank you.
Now, let me start with you because when the administration first rolled this program out in, I think it was last summer, I think you were quoted as saying it's, quote, even worse than expected or something like that. So why don't you just give us a background of what this is all about, how it came about, and for that matter, why you think it's such a bad idea.
Sure. So, I mean, the sort of most immediate timeline is it was August when the Biden administration made an announcement that it was going to do mass student debt forgiveness. But I'm going to back it up just a little bit, just to give how we sort of got to that point. Sure. I'm going to give you the full history of federal student loans, but federal student lending really kind of goes back to the 1950s, lots of different iterations. You get to around the 1980s, though, and it starts to look basically the way it does now. You have subsidized loans, unsubsidized loans, which are really just federal bureaucratic terminology for some loans. The federal government will pay your interest while you're in school and the grace period after, some you won't. But they're all really subsidized because the federal government says, we will push money to students that the private market probably wouldn't. Originally, it was to ostensibly private lenders saying, we'll guarantee you get a profit off of these, so that people would give money to students to go to college who, again, many of whom would not have gotten it, in part because of financial reasons, but often in part because there wasn't evidence that they were prepared to succeed in a college program that led to employment that would enable them to pay back loans. Starting in the 1990s, but solidified around 2010, we moved from lending where the federal government would guarantee these ostensibly private loans to where money was coming directly from the federal treasury going to students. So that's kind of broadly how this evolved. And what we saw really from the beginning of federal student lending was people saying, hey, we don't like how some of these loans work out. They don't go to schools that get good outcomes. Students are often taking on debt that they have trouble repaying after they graduate. And really you get reaching ahead of people getting very angry about federal student loans around 2011. You may remember Occupy Wall Street. It had lots of complaints about what was wrong with America, but one of the ones that they sort of crystallized around was the idea that college cost too much and federal student debt was too high. And so then we started to see people talk about really two things. One was, well, let's make college free to the consumer. In other words, we do it sort of like K through 12 schools. Taxpayers pay up front for the schools and they don't charge people. The other movement we saw was toward forgiving federal student loans. And this was, in the last 5 or 6 years, taken up by Senator Sanders and Senator Schumer and Senator Warren, who started pushing for mass student debt forgiveness, and not even capped typically. Sometimes it was capped at people $50,000 of debt, which is far more than the average student debt. And the Biden administration, actually, candidate Biden would say on the campaign trail, well, he thought there should be debt relief, but he never said unilaterally, never said that the president could do it himself. He said, well, I'd like to see $10,000 of relief per borrower done through Congress. The then Speaker of the House, Nancy Pelosi, said, the president does not have authority to cancel debt. It has to go through Congress. And so for the beginning year and a half of the Biden administration, there was lots of talk about, well, should we have executive ordered debt forgiveness? And the Trump administration had actually looked at this. Secretary of Education DeVos had ordered an analysis of whether or not it would be legal to do that, and she found no. The Biden administration said, well, we're doing an analysis of this, which took like 2 years, which was surprising to everyone because it seems he wouldn't commit to executive order to cancel federal student debt. But in August, we started to hear probably around July rumblings that he was going to have some plan to forgive debt. We looked at the possibilities, what was talked about, which was $10,000 or possibly more per borrower. And that was going to heavily favor wealthier Americans, because we have to understand that it's wealthier people who tend to take on debt because much of debt is actually for graduate school. And wealthier people are more likely to go to undergraduate school. And then in August, we were surprised when this final proposal said he was going to forgive debt of up to $10,000 for basically anyone, any joint filer making up to $250,000 a year. So basically everyone but the top 5%. But he added something to change that skew that everybody said would have been heavily favoring the well-to-do, to say if you took out a Pell Grant, you could get $10,000 more, so up to $20,000. That made it less skewed toward wealthier people, more toward lower income people, but it still would give relief of some type to about 43 million borrowers. That's what the administration itself said. And you have to understand there are only 43.5 million total people with federal student debt. So it would still be almost everyone with federal student debt would get something out of this.
Okay. So what's so bad about it?
Well, so there are numerous reasons, and I know.
Give these kids a break, right?
Yeah. Well, and there is that aspect of it. If you have federal student debt, you are probably happy to get some money back. Although we often hear that, well, if you get this relief, suddenly you'll be able to buy a home that you couldn't buy before, and that you'll pump it in the economy. And the economy would be great. And one of the arguments against this is you don't want to make inflation worse.
Sure.
I actually think that's overstated in terms of overall inflation, because what you're really doing is saving somebody that monthly payment. You're not giving them $10,000 to $20,000 right away. But it's certainly overstated to say, well, if you get $10,000 to $20,000 that you may have had to pay back, suddenly you're going to buy a house really doesn't make sense. But that's the argument for it. The arguments against it are myriad, but hard to see. So we can see the student who has debt, usually not a student, the graduate, often graduate of medical school or law school or business school, but we can see that person and say, well, it'd be nice if they had more money. What we don't see is, first of all, the cost to taxpayers. There are lots of different estimates of how much this will cost. They range from around $350 billion to $500 billion. It depends on how many people you think will take it up, how many would have had some of their debt forgiven before. But the Congressional Budget Office pegged it at $400 billion. We'll go with that. Why not? You know, what's $100 billion between friends? And so if it's $400 billion, the first thing you don't see is the cost to taxpayers. Now, to put this into some perspective, $400 billion is more than the GDP of most countries. That's a lot of money. It comes out to about $2,400 per taxpayer if we divide that by the number of tax returns filed with the IRS. That's a big cost for everybody, and that's probably the first thing we should think about is, how is this hurting taxpayers? But it's worse than that. One of the worst aspects of higher education is tuition inflation. The price of tuition, we kind of know for decades, has been on a skyrocket. And the reason it's been on a skyrocket is the federal government will give people money to pay basically whatever a college charges. It's fundamentally a third-party payer problem. The person agreeing to pay the price is agreeing to pay it not primarily with their own money, but money they get from a third party, from taxpayers. And those taxpayers aren't like, if it were truly free market lenders, as I know I'm incurring risk with this loan and I'm going to take a chance. The taxpayers are told, you're going to do this. And so we've had this massive problem of tuition inflation, and this would only make it worse by signaling to future borrowers, if this happens, borrow even more. Because what administration after this has happened would be willing to say, okay, these people were deserving, but you folks, now, or in 5 years or 10 years from now, aren't deserving. They wouldn't be able to say that. And you could say, well, now we have a national emergency. It's always possible to find, I think, another reason that you can say, well, these folks really need relief. What made this even worse, though, than my original concerns was they've added a bunch of additional things that go beyond this cancellation, where they will change something called income-driven repayment, which, by the way, everybody can get now if they're struggling to pay their loans. People who are struggling are not all forced into bankruptcy or something. There are already programs for them. But this would make those programs much more generous. They would count less of your income as what you have to repay. They would change a whole lot of other parts of student lending. And so that's what made it actually even worse. It's not so much the cancellation got worse, it's all the other things they want to do on top of it.
That's the proposed rule that just came out about a month ago, isn't it?
Yes, so if, I don't know how much we want to get into painful regulations.
Sure, we can, that's maybe on the back end.
But yes, so this is at least going through the sort of ordinary regulatory process.
And you submitted a comment letter.
That's right.
For
NCLA
NCLA,
submitted
right?
a comment explaining why that income-driven repayment proposed rule is unlawful. We focus mostly on the legal problems of it, but obviously there are many perverse incentives and economic costs and that sort of thing as well.
I don't want to jump ahead too much, but in yesterday's oral argument in the Supreme Court case, some of the justices were talking about just the general fairness or unfairness of this. And I'm sure you've thought through, like, what if you didn't go to college? Or what if you took out a big loan and you just finished paying it off last year? Do you have any views on that?
Yes, well, it is unfair. And it is a perverse incentive because we say more and more to people, don't be responsible in trying to minimize how much you spend on higher education. And we should really want people to make a value proposition saying, how can I get what I need at the lowest cost possible? And so there are people in particular who went to college and they will get that college premium. We need to understand that the average person who has a bachelor's degree over their lifetime is expected to make about $1.2 million more in earnings than somebody who ends at high school. If you get a professional degree like a lawyer or doctor, you make about $3.1 million more dollars. And so there is a payoff to go to college. And there will be people who went to college and get that. And one of the arguments is, well, this is really fair because people who go to college earn more, so they'll pay more in taxes and they'll be the ones kind of responsible for this. But there are many people who went to college and didn't spend a lot of money. They often said, I'm not going to go to the school, that has the on-campus water park, and that costs me a whole lot of money because I like to party, and I guess I like to swim and go down big slides, and things like that, who said, I am going to get the least expensive education I can that focuses on the education part. Those people in particular are the ones who will suffer because they may get that earnings premium. They'll pay more in taxes for the people who said, no, I'm going to take on big debt and go to the place with the water park or do all the partying that is so often associated with college and not be focused on the education part of it. And they are the sort of most immediately unfairly treated. And then the people who took on student debt and worked hard to repay it because they said the right thing to do is repay the taxpayers who have given me this money, they also are being treated unfairly because what we're essentially saying with this is if you didn't repay your debt, as quickly as you could, or even if you just followed the standard 10-year plan, you're not going to get this relief because you did it, and people who didn't pay promptly will get it. They are also suffering. And then, of course, there were the people, as came up in the argument, who said, well, maybe college isn't the right way to spend my resources. Maybe I'll start a business. And then those people end up paying more in taxes to cover the costs of people who went to college, who will get that earnings premium, but don't want to pay back $10,000 or $20,000 of that.
So just quickly, what's the current status of it? Is it likely to go through? Is it hung up? I think they started registering people through some web portal, and then they stopped, I guess.
Well, I'll let you guys handle what's going to happen in this case. But they began to accept applications for it, say, hey, basically I want it, and it's not hard to get it if it's not stopped in the courts. But they did have to cease doing that because I think the administration didn't expect to lose in any court. And when they did, they had to say, okay, well, we can't, probably in good conscience at least, continue to take applications. So right now it is stuck. But as soon as there is some resolution of this case, I believe they said it's 2 months afterward, they will either restart. Maybe after the case is over, they'll immediately restart. But if not, then they have to sort of retool.
Yeah, I mean, I don't know how much time they'd need to just push a button.
I think they can do it immediately.
Cancel all the people that are in the system.
Yeah,
already.
they said for 2 months after the Supreme Court resolution, they'll extend the pause. But they said they made no guarantees about when they won't start canceling loans if they win. So it could be an hour after, a day after. I guess it determines how long it takes for the bureaucracy to start working.
They have one problem, and I don't know how intimately involved they are, but there are loan servicers who are contracted with the Department of Education. And when this is resolved, they may have a role in sort of telling borrowers, hey, this is what you can get. And so I don't know, it takes a while for them to restaff. We have to understand that for the last 3 years, basically, there's been a pause on repayment, and all those servicers have basically not staffed up because they don't have much to do. Mm-hmm. This is one of the reasons if they lose in court, they need that 2 months, and a reason that they think they're gonna have higher defaults is it takes a long time to get that apparatus back in place to start getting these loans repaid. I don't know whether those guys would have a big role in processing someone's forgiveness, but they ultimately do have to know, somebody has $40,000 of debt, they get $20,000 canceled, they better make sure they know that $20,000 is gone.
All right, so that's a good segue into what's going on in the courts. Shang, you listened to the oral argument. We've alluded to a Supreme Court case that was argued just yesterday. We both listened to it, but why don't you give us an idea of what's going on in the courts?
So as Neil mentioned, it took the Biden administration quite a long time to come up to announce what it's going to do. And in part, that's because it was for about a year and a half, 2 years, it was really struggling to figure out, well, how is it going to justify authorizing student loan forgiveness when the Speaker of the House, Nancy Pelosi, straight up said the president has no authority to cancel debt. And everyone thought it would be under some provision of the 1965 Higher Education Act. And many were surprised when August last year, the Biden administration instead picked out a wholly different statute called the HEROES Act that was passed in initially passed in 2001 and amended in 2003. So it's known as the HEROES Act of 2003. But it was passed right after 9/11, and really all the legislative history of that act indicates the act was meant to help soldiers who may have to deploy overseas to fight wars and may have trouble paying off their student debt. If you're a National Guardsman and you were a lawyer, and then now suddenly you have to be an infantryman for a few months, you might not be able to pay off your fancy law school debt. And so there's some financial assistance in that. And just to, I'm just going to quote from the act itself, the operative language here. It says, it authorizes the Secretary of Education to waive or modify any statutory or regulatory provision applicable to student financial assistance when the Secretary deems it necessary in connection with a war, military operation, or national emergency. And a further requirement of that is that any kind of waiver and modification under the HEROES Act has to be necessary to ensure the affected individuals, that is the borrowers, are not placed in a worse financial position in relation to that financial assistance because of their status as someone affected by the national emergency. And the Office of Legal Counsel, which is part of the Department of Justice, said that second requirement means you might be able to provide under the HEROES Act some kind of debt relief or debt modification program to people affected by COVID-19, which they said was a national emergency under the Act. But that required that necessary to ensure not in a worse not placed in a worse financial position means you can't give the recipients a windfall. You can't make them better than they would have been had they not been affected by the national emergency. So, the idea that there is an earthquake and you lose your job and you can't pay off your loans in a while, the government can't give you so much money or so much benefit that you would have been better off had the earthquake not destroyed your job. And so that's sort of the setting background. And based on this 2003 law that was really, everyone agrees, was meant to help soldiers who who go to war, and maybe non-soldiers who are affected by national emergencies, like a terrorist attack or a hurricane or something like that. The president and through the Department of Education said, well, COVID-19 is a national emergency and affects everybody. So what I can do is use this HEROES Act, which honestly no one really thought of much before. I'm going to use this HEROES Act to provide the relief that Neil just talked about, that everybody making under 250 grand gets $10,000 of their loans forgiven. And
when you were reading from the statute, I don't remember you using the word forgiveness or
that's right.
cancellation.
So the statute says waive or modify, and this became a major issue in the lawsuit. In fact, it was so just to give a little background, a number of organizations sued, including NCLA and Cato. NCLA, in fact, represented Cato in a lawsuit that's currently pending in the District of Kansas. I guess we were maybe a week or two too late because the states, a group of states led by Missouri and Nebraska, sued in Missouri in late September. Among the other lawsuits, a couple of plaintiffs, private plaintiffs, Brown and Taylor, sued in Texas in early October, and we sued in mid-October. But those guys made it to the Supreme Court, and we missed the boat. And so our case, we'll talk about it a little later, but our case is now in a kind of a holding pattern, waiting for the Supreme Court resolution. But in the Supreme Court case, what they did is they took the two cases, put them together, and it was argued just yesterday. And the Chief Justice's first question to Solicitor General Preligar, who is representing the federal government, is, doesn't modify mean you have to change a statute just a little bit? And whereas here, what the government has done is use this modification power, and they took out there's some provisions of the Higher Education Act that says, well, the Secretary of Education can forgive debt for people who become disabled, or forgive debt for people whose school close in these kind of exigent circumstances. And what the government has done is say, well, in modifying that debt cancellation for forgiveness provision, they're going to take away, cross out your school is closed and cross out you're disabled and just put the conditions, whatever conditions they want. The conditions here, which happens to be you were, alive in the pandemic and you make under $250,000, which is 95 or 96% of student loan borrowers. And so how the government has interpreted the word modify to mean rewrite. And the Chief Justice said that's not how we usually interpret the word modify, and that's a big part of the argument of the Supreme Court. And the Solicitor General's response to that, well, it also says waive or modify. So the question is then, well, maybe this waive or modify means waive expands what you can do with modify, and if you can waive something, then you can waive perhaps waive the debt. Mm-hmm. But I don't know if that's really correct either, because some of the justices then say, well, it doesn't say waive the debt. The statute says waive a provision. right? There might be a statutory provision that says, for example, if you work for a public service employer for 10 years, you get your debt forgiven. Maybe the waiver would say, well, we can waive a couple years of that. That would be waiving a requirement of the provision. It doesn't, a statutory provision that's different from waiving the debt itself.
And then one of the justices pointed out, I can't remember which one, that the word cancel is in some other parts of the same statute, right?
Congress has, because student debt cancellation has been such a political hot potato, and because of all the very complicated and perverse incentives that cancellation of debt creates, Congress has been very careful in crafting statutes that cancel debt. And when they craft such statutes, they make very clear that this is a statute that allows the Secretary to cancel debt and creates very explicit conditions, including in the public service employment context. You must work for a public service employer, and they list what's a public service employer, and they say you must work there for 10 years or 120 months, and those are very specific conditions. Whereas this HEROES Act doesn't list any of those conditions, doesn't even say the word cancel, doesn't say the word forgive. And that sort of brings up this judicial doctrine that the court seems to be very focused on. The Chief Justice brought it up multiple times during the oral argument. Justice Kavanaugh and Alito piled on as well, the judicial doctrine called the major questions doctrine, which says if Congress is to, if an administrative agency, here the Department of Education, is to enact some sort of policy that has very significant economic or political effect, then we're not, the court is not going to read a statute to authorize the agency to do that unless the statute has very explicit language that makes it very clear that the agency has that authority. And in the last year in the West Virginia v. EPA case, the court said an arguable or colorable language is not enough. So maybe it's colorable that waiver or modify means cancel. Maybe it is, plausible. But under the major question doctrine, that doesn't fly. You have to use very explicit terms like cancel, like forgiveness, which you just don't see here. And the rationale for the major question doctrine is really the separation of powers rationale. It's to the idea it's Congress, only Congress can enact laws under the Constitution, under Article 1. And Congress is not supposed to be taking its legislative powers and giving it to executive agencies like the Department of Education.
What's the argument that this is not a major question? Because you're talking about $500 billion and 43 million affected people, plus the taxpayers footing the bill.
That's a really good question.
What did the Solicitor General say?
The Solicitor General's response in the briefs and in the argument, she conceded that, as she must, that hundreds of $billions, major economic effect. Student loan cancellation has been debated in Congress for many, many years. So therefore it's a major political effect. But she says that's not enough, and would say, well, the major question doctrine would only affect regulations, but not benefits programs. And this is a benefit program that doesn't, infringe upon, necessarily freedoms or liberties, and therefore we don't have to worry about the major questions doctrine here. But that doesn't sit well with many of the justices who noted, again, the major question doctrine doesn't serve to restrain regulations. It serves the separation of powers purpose. And the idea is like if we will presume Congress didn't mean to violate the Constitution, because if Congress authorized the Department of Education to rewrite student financial aid statutes, that would be Congress divesting its legislative powers onto an executive agency, which would be a violation of Article 1. And the major doctrine says, well, even if the language is colorable, suggests that Congress may have told the Secretary of Education he has this power, we're going to presume they didn't, because otherwise we've created a non-delegation problem.
Right. I don't remember that coming up in the argument, which is sort of disappointing
strange
to me.
that the non-delegation doctrine didn't get a lot of play. It got a little play in the I think it was the Solicitor General of Nebraska was asked made the point that when you authorize an executive agency, when Congress authorizes an executive to rewrite the law, that violates the bicameralism and presentment requirements for legislation. And that decision was a 1996 decision in Clinton v. New York, where the Supreme Court said, line item vetoes, where the president goes in and crosses out parts of duly enacted legislation, was unconstitutional. And this is really kind of the same sort of, presents the same sort of problem, where the Secretary of Education claims the ability to go in and cross out part of a, let's say there is a statute that says you get your loan forgiven if you're disabled, and it crosses out the disabled and adds if you make less than $250,000. So that's just clearly rewriting the law, and that would be, I think, a non-delegation problem. It was unfortunate. I think we didn't see as much talk about non-delegation, and the justices were more focused on the issue of major question.
Well, they were also focused on the threshold issue of standing.
Yes,
and that's been a big issue, not just in these cases, but all the other ones, including our own case.
Right. So there's this judicial doctrine called standing, based on Article 3 of the Constitution, wherein to get into court to challenge a particular regulation or a particular government action, the plaintiff has to demonstrate that you suffered some sort of tangible injury from the government action, and that the court's relief is going to redress that injury. And here there's two groups of plaintiffs here. There's a group of states and two private plaintiffs, and they advance different theories of standing. I'll start with the private plaintiff because I think it's a little easier. The private plaintiffs argue that they should have had an opportunity to comment on the Secretary's debt relief policy, and to comment and ask essentially for more money. One of the private plaintiffs, Brown, didn't get any relief, and with the second private plaintiff, Taylor, I think got $10,000 relief, and said he should have got an opportunity to ask for $20,000 worth of relief. And you see there's this disconnect that might be, even if that's an injury, the court sees this disconnect here. Well, you want more money, you want more debt relief, but they were asking for to stop the program, right? So that seems to be a problem. And the Brown and Taylor, what they said was, well, if we stop this program, what we're going to do is force the Secretary to go back to the drawing board and enact a new program under a different statute, the Higher Education Act, instead of the HEROES Act. And under the Higher Education Act, Brown and Taylor would have an opportunity to get comment.
So just to be clear, the HEROES Act specifically says
that's right.
The Secretary does not need to go through notice and comment.
That's right. The HEROES Act says no because it's meant to be, I guess, an emergency statute. You see this all the time in emergency kind of statutes that you can. The agency can enact policies without notice and comment.
Got it.
The court, I think, was a little skeptical of that standing argument, mainly because there's no, even when asked, the attorney for Brown and Taylor conceded there was no case where a procedural violation like the lack of notice and comment was, you were permitted to use that as standing when the relief you sought was a different program under a different statute. And here the relief would be, would the government then go back to the drawing board and issue a new debt relief program that potentially could encompass Taylor and Brown, but again, it would be a different program and a different statute. Right. So that, I think, would be treading new ground. It doesn't mean the court will necessarily, stop there, but many of the justices were skeptical that modern standing doctrine extends that far. The states, I think, have a stronger basis for standing, and the states raised many different types of arguments, but the best argument, and what's most discussed by the justices and the litigants, was the fact that Missouri has a state-created loan servicing organization called MOHELA. And MOHELA gets revenue from the Department of Education through contracts for servicing student debt. And something like 70 or 80% of its revenue comes from these contracts, which are per debtor, per borrower, per year contracts. And what the student debt relief program, the Secretary's program, would do, it eliminates so much debt, it will completely eliminate the debt of about half of borrowers around the country. And which means, statistically, MOHELA would lose about half of its contracts. If it gets money from each contract and those people no longer have any debt, those contracts would disappear, and the amount of revenue that MOHELA gets every year would fall substantially. And that was the state's, I think, the strongest theory of standing. The Attorney General Proligar's counterargument to that is that by state law, MOHELA and the state of Missouri are completely separate corporate entities, and there's a clear division by state law, a clear division between MOHELA assets and state assets and liabilities, such that they do not intermix. So when you sue MOHELA, it's a corporate entity service debts. It gets sued by borrowers sometimes, and the borrowers can get recovery from MOHELA, but that will not draw from Missouri's treasury and vice versa.
And
can I just give a little history on that, because it's important. I mentioned that there are loan servicers, and that the history of federal student lending is long and complex. The federal government incentivized states to create entities like MOHELA in the 70s that were supposed to be state-level guarantee agencies that would say, okay, here in the state, if you are a lender, an ostensibly private lender to a student borrower, and you are afraid that somebody will default on that loan and you'll end up losing money, these were state entities that were supposed to insure those lenders against loss. And the federal government incentivized states to do it. There was various tax breaks and things like that. And so in a way, those are clearly, they're sort of like Sallie Mae. If you know Sallie Mae, it was a federally created entity to, again, guarantee federal student loans. These were at the state level, driven by the federal government, and they were supposed to be quasi-state entities. And over time, when we went to fully direct lending, in other words, direct from the Treasury, the federal government sort of grandfathered some of these, we probably shouldn't technically call it grandfathering, but they took a lot of these entities that had been guarantee agencies and say, now you will be given these contracts to execute federal student loans and to service federal student loans. So it's not like MOHELA was something just the state of Missouri created. It was something that was part of this federal evolution in in student lending.
so one hiccup in this was that MOHELA could have joined the lawsuit.
That's right.
But didn't.
And that's a really strange about what happened, because everyone agrees, even the federal government agrees. If MOHELA had sued, MOHELA, it's an independent corporate entity and therefore could sue on its own. If MOHELA had sued, everyone would agree MOHELA had standing to bring this lawsuit. And so many of the justices questioned, why is MOHELA not here? And that's, we don't really know. The record's pretty vague on why that is. And certainly the governor of Missouri actually appoints the leadership of MOHELA, so presumably he could direct them to sue, although I suspect MOHELA may see fewer federal contracts if it challenges the Department of Education so directly. So there might be some deterrence effect there, although that would just be speculating.
Mm-hmm. So NCLA submitted an amicus brief in this case. Why don't you just, did any of those issues kind of get aired out? Tell us.
Certainly. So on the MOHELA question, I think it is a strong standing argument, but at the same time, in the oral argument, it did seem that everyone did also agree this will be treading on kind of new ground as well, because there's not a clear case where a government entity has been able to sue on behalf of a completely separate, financially separate entity, corporation it created. There is case law where government is able to sue on behalf of a corporate entity it created where the assets intermingle somewhat. So I think that'll be a question for the court to tease out. So both the Brown and the state's cases present, we think, present pretty good major questions arguments. But on standing, certainly we think they're strong standing arguments, but at the same time, it does require kind of treading new ground. And
Oh, I was just going to add, although you probably know more details about it than I do, but MOHELA, money they get, they do give some of it
That's
to
right.
fund, it's I think a scholarship
Yep.
program
Yeah.
in the state, and it's probably, I don't know all the legislative background of that, but again, remembering that MOHELA was created originally, if I'm correct, to be one of these servicers because of federal incentives for states to do it. That is probably at least a vestige of the fact it was actually a quasi-state entity intentionally. And this is probably as that market has evolved because the federal government has changed away from the old subsidized loans to the direct lending. This is probably how MOHELA has evolved. Yeah. Which I think, I'm not a lawyer, by the way, so everybody knows lawyer better than I do, I'm sure. But it seems to me that makes some sort of difference, that this was, the history of this entity was to be sort of a functionary of the state, and they still supply some money
And
to
I
the
think
state.
that should make it. And in fact, that was discussed, the fact that MOHELA does contribute to scholarships. But the problem is this case kind of skyrocketed to the Supreme Court. And as a result of the fast pace of this case, the record on the relationship between MOHELA and the states, how much money it contributes, why it contributes, what exactly it contributes, just isn't really there. We know it's contributed about $60 million over the last however many, 10, 15 years, but it was also strange because the Attorney General of Nebraska was making these arguments about Missouri
Or Solicitor
entities.
General.
The Solicitor General of Nebraska was making these arguments about Missouri law, which made it kind of awkward, I think. But in any event, so when he said, "Oh, these are Missouri political questions that I can't talk about," sometimes it was one of the answers. I think if there had been a fuller record, I think you much have a stronger argument. And there is a record of contributions, but there's not a clear record of why those contributions are. And one of the things that NCLA's amicus brief offered was an alternative to what we think are sort of maybe newer or more groundbreaking theories of standing that both the private plaintiffs and the state plaintiffs bring. And the alternative is based on the statute called the Public Service Loan Forgiveness Program. And what that statute says is if you're a borrower and you work for a public service employer, which is defined by the statute, it includes states, it also includes nonprofit companies like Cato. If you work at one of these organizations for 10 years, you get your entire balance of student loans forgiven. So
After the 10 years.
After the 10, exactly, after the 10 years. Now think about that. It's meant to encourage college-educated borrowers who have substantial debt to go into public service, where you'll probably get paid less than the private sector, but you get this debt forgiveness to incentivize you to go there and stay there for 10 years. But if you get all your loans forgiven today, that incentive disappears, right? So you're no longer incentivized to work for whether it's a state government or Cato, and as a result, Cato and the state governments are less able to attract and retain college-educated, talented employees. And that's the theory that we suggested that the Supreme Court should consider.
Yeah, that's a benefit, a competitive advantage that Congress legislated on behalf of state governments, nonprofits, et cetera.
And
this kind of the current program just kind of cuts the legs out from under that because everybody gets their
everybody gets it.
Yeah.
Why
Even
work
if you're
for
not
Cato?
working for anybody.
Why work for the state of Missouri and take a lower paid job if you get all your loans forgiven today? And that's not the only program. There's also similar programs for teachers. There's program for social workers, law enforcement, the similar kind of basis, and there's no reason to participate in those programs either if you get all your loans forgiven today. And we suggested to the court that this might be an alternative theory of standing that's more that doesn't require any inventiveness, and it's just a competitive business harm. It makes it more expensive for employers to hire people. Costs money, and money, even $1 of economic injury, the court has said, is enough for standing.
I just want to make a higher ed policy point on this, in part because I have said for many years the public service loan forgiveness program really shouldn't exist. There are big problems with it. But it's important to understand with regard to this case, even if we think it shouldn't exist, it is part of the labor market. Everybody involved in the labor market knows this is here. So even if I think it shouldn't exist, the fact of the matter is that is part of how all nonprofits compensate versus how all for-profits compensate. So it is still a harm to us if extra constitutionally the president says, okay, well now we're going to forgive these debts in other ways. So even if you think public service loan forgiveness, or as in my case, I don't think any of these federal student loan programs should exist, it is still a concrete harm because whether I like the program or not, it is a part of the labor market.
Yeah.
And Cato as an employer can't actually control or monitor whether its employees participate in this program. They could work in Cato for 3 years, go somewhere else, work there for 7 years, and then submit their paperwork and get their loans forgiven. So even if Cato, were said, we don't like this program and we discourage it, they can't actually stop any of their employees from benefiting from it.
And the employers are well aware that it's there. So
the states did not pick up on this
The states did not. Actually, so it's funny, there were two group of states. So this group of states sued and did not make that PSLF argument. The state of Arizona sued around the same time we did on its own and did make that argument. And we thought that was interesting. But then what happened was the state of Arizona, they had an election. The election resulted in a new attorney general who had different policy priorities as compared to the old attorney general. And Arizona, we understand, has dropped that lawsuit. So it's so I believe we and Cato are the only pending cases that assert the standing based on the public service loan forgiveness program. Okay. Although anybody can do it, all you need to be is a public service employer, which includes every state. It includes every 501c3 nonprofit entity and includes other entities too. The American Bar Association won a case a few years back when the Trump administration tried to restrict access to the public service loan forgiveness program, and they sued and they said we have standing as an employer to challenge this, and the DC Circuit agreed with them because they suffer clearly an economic harm.
Okay, so we had a couple of other arguments in our amicus brief that are relevant to the argument, although I don't think were central.
Certainly, we really pressed the non-delegation doctrine in our amicus brief. And I think the non-delegation doctrine and the major questions doctrine is what the court really focused on, whereas the non-delegation doctrine is what we focus on. But they're not separate. The non-delegation doctrine asks, could Congress have possibly, under the Constitution, delegated this authority to forgive debt to the Secretary of Education? The major question doctrine asks, did Congress do it? And the reason the non-delegation doctrine is almost like a backstop for the major question doctrine. The reason why we're skeptical on this, did Congress empower the Secretary question, the reason why we're skeptical is if Congress did, they would violate the non-delegation doctrine.
Because it would be wholly discretionary.
Right, because they would be...
The Secretary could do anything he or she wanted, I guess, right?
Why stop at $250,000? Why not $1 million? Why not $10 million? Why stop at $10,000 of relief? Why not $100,000 of relief? There's wholly not, if you have this power to rewrite any statute, the Secretary is making the law and not Congress. And that's sort of actually, if, and I wish this issue was ventilated a little more during oral argument, because Solicitor General Preligar kept on saying, Congress couldn't have possibly anticipated emergencies in the future. And so what Congress meant to do is invest this awesome, lawmaking power in the Secretary of Education, so the Secretary can respond to those future emergencies. Well,
the proverbial magic wand.
Exactly. Well, she is basically saying Congress gave lawmaking power to the Secretary of Education. And the other argument we made was the appropriations clause. It's the fact that this is not just a regulatory authority. Solicitor General Preligar said major question doctrine shouldn't apply because this is a benefits program and not regulation. But as a benefits program, you're giving people goodies, which cost taxpayers money. But the Article 1 of the Constitution clearly states Congress has the power of the purse, and it's Congress that must appropriate funds. And this is actually something that Justice Thomas picked up on and asked Preligar, aren't you appropriating funds by giving grants, up to what, 300, 400, 500 billion dollars? And her kind of tongue-in-cheek response I wasn't impressed was, well, this isn't literally drawing money from the Treasury. It's basically forgiving money that's owed to the Treasury. And that's a distinction without a difference in my mind. And I think in the minds of hopefully many of the jurists.
Is this part of your scope of research, whether forgiving loans is an appropriation or
Well, I mean, I don't, because I'm not a lawyer, I don't get into all the terminology, but I was ecstatic when Thomas said, aren't you essentially turning loans into grants? Yeah. Because that is what you're doing. And we have a grant, we have multiple grant programs, but there's a really big one called the Pell Grant. The federal government says there is some money that we will appropriate as grants that you do not have to repay. What the president's done is said, $400 billion of loans, now they're grants. That, for all intents and purposes, that is an appropriation. And her argument was, well, that money kind of like, it's already out there, so whatever. Well, but it's a very different thing.
And our amicus actually points out what she said just simply isn't true. Because part of this program, a little part of it, is that some people have been paying down their loans during the pause. And as a result of paying down their loans during the pause, they may no longer have any loans, or they might have less than $10,000 of loans. So what the program does, not only do they get $10,000 of forgiveness, they get what they paid in during the pause back. That money was in the Treasury. So at least part of the loan forgiveness program, perhaps a small part, because anything's a small part out of $400 billion, is drawing some money from the Treasury. And that was clearly done without congressional authority. But I think the wider point is that these debt instruments owned by the federal government are assets in the Treasury. And if you start forgiving them, you just wipe out half of them and devalue the other half substantially. That's how I don't see how that's different from drawing, drawing money from the Treasury. And in fact, it really isn't. And one of the things our amicus brief said was, if you go back to the early republic, the 1700s, 1800s, there was no actually what was money. What money was just debt instruments. Was privately issued debt instruments from banks. So when money is drawn from the Treasury in 1804, it would just be transferring debt instruments owned by the Treasury by the Bank of Kentucky or the Bank of Maryland. And if that's, if that clearly is an appropriation that's only authorized by Congress. So if we are to then fast forward to today and take away debt instruments, I just don't see how that's any different. And I'm glad Justice Thomas asked that question, but I don't think the federal government's response was persuasive.
And if I recall correctly, the states didn't really focus on that issue in the briefing?
No, unfortunately not so much. The states really focused on the major questions doctrine, which it's a litigation tactic.
Sure.
Certainly that major questions doctrine was at the forefront of the Chief Justice's mind. Justice Kavanaugh weighed in on multiple times, and Justice Alito as well. So it's some of the maybe so-called swing justices seems to prefer that doctrine over maybe more traditional separation of powers principles, such as the non-delegation and the appropriations clause.
So there's one other issue I want to get to that we raised in the amicus brief. And I think, as best I can tell, we're the only ones who seem to have a problem with this issue. And that's the Solicitor General kept coming back to the notion that, well, 3 years ago, when the pandemic first started, the Secretary of Education put a pause on your payment and interest obligations so that nobody was having to pay
That's right.
or accumulate interest throughout the pandemic anyway. And that was based on the HEROES Act. So why is this really any different? That was $150 billion or whatever.
So that is a strange response, and so let's give you a little background.
Sort of like
here.
if we can do that, why can't we just go a
Right.
few
So-
inches further and just cancel the debt outright?
Yeah, and so our brief actually made clear that's actually just, again, factually not true. Preligar's argument was, well, the HEROES Act we've been invoking it for 3 years to make sure that to pause payments and accumulation of interest since March 2020.
Right, across both
every-
administrations.
Both administrations,
So there's bipartisan agreement.
and with no and with no requirement. It's not just for poor people or $250,000 in earners. Everyone gets it. But that's actually not quite true, because when the pandemic first hit, Secretary DeVos did in fact announce through a press release, mind you, that they're going to pause payments. But then just 1 week later, Congress enacted the CARES Act, which statutorily paused payments. So it doesn't matter what the secretary said. Congress was the one that really paused payments, and Congress put a very clear sunset on that pause. The pause was to last from March 2020 to September 2020, 6 months. That's it. The pause. It's actually an exercise of not just Congress' legislative power; it's an exercise of Congress' appropriations power. Because what does it mean to forgive interest? It means to pause the accumulation of interest. It's essentially a forgiveness, because you're supposed to pay back a certain amount of interest that goes up, and then if every month we wipe that out, that's equivalent to giving you a grant equal to the amount of interest that would have accrued. So Congress appropriated whatever amount of money, it's equal to 6 months of non-accrual of interest. And what happened at the end of that 6 month is then President Trump asked Secretary DeVos to extend that pause, which is very close to the eviction moratorium case that went back to the Supreme Court about a year ago. And the Supreme Court said, the Department of Health and Human Services can't extend a congressionally enacted eviction moratorium. And this is presents the same kind of problem. And what's more, the Secretary DeVos didn't invoke the HEROES Act the first time she extended it. She invoked a provision as directed by the president of the Higher Education Act for economic hardship, which is actually really narrowly tailored. You have to be making close to the minimum wage to qualify for it. So that clearly couldn't have covered every 45 million student borrowers in the country. But she did it anyway. Nobody challenged her. And then comes September, so she extended it to September. Then comes September, then she, I think, looked at it and was like, oh man, that Higher Education Act is not going to fly if you face a legal challenge. And that's when she issued the HEROES Act and put in a Federal Register notice saying so. And she extended it for 1 month because I guess her boss lost the election and she was out 1 month later. But when Biden came in, he kept on extending it over and over again. But what's really different from the Biden extension actually is that Biden didn't publish anything in the Federal Register. Every one of Biden's extensions is through a press release and without mentioning the HEROES Act. So I think this whole position of the HEROES Act, we've been invoking the HEROES Act this entire time for 3 years, is simply untrue because the HEROES Act was invoked once to extend the pause for 1 month. So that, for one, is just simply untrue. And second, our amicus brief makes clear that the pause presents really the same sort of problems as the cancellation. For one, if you're not collecting interest, you're giving people grants, and Solicitor General Preligar conceded it was about $5 billion a month of foregone interest that's been forgiven, which amounts after 3 years to be about $150 billion, and that let's forget about the Article 1 stuff. Under the major questions doctrine, seems to be economically and politically significant enough to trigger that sort of scrutiny. Never mind the fact that Congress never appropriated any of that. Congress appropriated only 6 months worth of interest cancellation, not 3 years.
So we effectively argued, don't rely on the interest and payment pause as your justification for
Right.
then extending it to cancellation, because that was
Well,
equally illegal.
So exactly. So one of Preligar's argument is the cancellation is equally lawful as the payment pause. But I think she starts from a fundamentally flawed premise that the payment pause was lawful. And our position is the payment pause was unlawful to begin with. We agree with her. Their lawfulness is equal. But we think both are on the unlawful side.
Let me just go back to one thing I think you said was when Congress did the 6-month payment and interest pause, they specifically appropriated funds for that?
Well, by implication, right? The Congress does, for example, in the public service loan forgiveness program, Congress didn't appropriate a specific amount to cancel for loans to cancel, but they said anybody who anybody who qualifies for the program gets canceled, and so by implication, that's the appropriation authority. So Congress puts a limit on that appropriation authority because it requires the participation and meeting of all the program eligibility. And what Congress didn't do is give the secretary any discretion in determining whether someone is participating as a PSLF eligible. Because if Congress did give the secretary discretion, the secretary would be the one saying you get money and you don't get money. And the secretary can't exercise the power of the purse. So here, Congress said, we're going to, create 6 months of cancellation, interest cancellation, and that's a specific amount, and the secretary can't exceed that, can't be given discretion to give more than what Congress has authorized.
Okay. All right. I want to get to some questions.
Oh, sure, of course.
But first, if you got key takeaways or final thoughts, this might be a good time to do it.
No key takeaway. I think we hit all the big ones.
All right.
My perspective is just terrible higher education policy, although notably it's on top of a lot of other terrible education policy. And one thing I might add is as I think I noted, we have lots of ways to get your loans forgiven already. So public service loan forgiveness is one of them. Income-driven repayment, which actually comes in numerous different flavors. And one of the reasons it seems, at least politically and in terms of the public policy debate, we are at the point of trying to find a way to say we can cancel all debt is because people have found all of these other programs kind of overwhelming to determine, first of all, which one you should use and then how those work. But that points, I think, to the fact that this is probably not really legal. I'm not a lawyer, so I can just use terms like legal or not kind of nebulously, but it's probably not legal. And it's because we have actually seen Congress try and deal with debt problems in all sorts of ways, with all sorts of programs, and it would be strange if they had actually given some of the power to say, we could just have the secretary cancel it all. And I think what we're seeing is about 2 decades of people struggling with this idea, how to deal with student debt, and finding that all these different programs the federal government creates that are clearly about forgiveness are too complex, and politically people just want it to be forgiven so they don't have to enroll in these things. And that's sort of a bigger part of the context of the policy that I think has brought us to this place. And the other thing that strikes me as odd is I think the government argued that it's very clear that in HEROES you can cancel debt. Then why did it take the Biden administration about 1.5 years to release a report that they promised at really the beginning that was going to say whether or not they could legally cancel this debt? If it were that clear, it seems like that report could have been written right away.
So let's take some questions.
Based on yesterday's Supreme Court oral arguments, what is your reading? Would you like to predict how it would go?
That's tough.
A.
Yeah.
B, do you think that Biden administration, I'm kind of assuming here, let's say, hypothetically speaking, they may lose a case, but it could become, politically speaking, a bigger issue in the next presidential election and may benefit Democrats?
So on the first question, it's always tough to gauge what the justices will do based on oral argument, because sometimes they don't show their hands. But here, I think if you divide the case up into 2 parts, that's kind of the merits, whether this is lawful or not, and second, whether the plaintiffs have standing. I think on the first part, I would be fairly confident there's 5 or 6 justices at least who think this is an unlawful program. And in part, I think this why we took this case on the merits is such a slam dunk that you have a single bureaucrat who's just doling out $500 billion worth of benefits. On the standing is I think a little trickier, and I think we think the Mohila standing should stand up, and we think also our PSLF-based standing should stand up as well. But at the same time, some of the justices were pretty aggressive in asking questions, and that might indicate some level of skepticism towards that Mohila-based standing. So we might see, a split decision, or we would like and we expect, I think, to see a decision striking down the policy, but we might see a decision where they find there's no standing. I don't think you'll see a case where the court will find there's standing, but the policy is lawful. That's I think off the table.
Yeah, I'll just say a little about the politics of it. And I may do policy, but the politics of it, I think you're right, is that when people hear just loan forgiveness, they tend to think positively about that because it seems like you're lifting a burden from someone. But we did some polling, some survey work that found once you explain to people the costs and the unintended consequences, it becomes a majority, I think by a lot, that opposes cancellation. So once you explain, well, you're likely to see more tuition inflation if people think they can take loans that they won't have to repay. That is very unpopular. So I don't have a good sense for how it would play politically, but if we're going to have a debate about it, I think it loses politically once people hear about the downsides.
Rich?
I have a question about the standing issue. From what you're saying, it sounds as though Cato's standing perhaps is somewhat stronger than the standing of any of the plaintiffs in the Supreme Court. From what you're saying, it could very well be that the Supreme Court rules no standing, and then the very next day, the Department of Education goes ahead and says all loans are canceled. What can NCLA and Cato do to prevent that from happening, to go forward with their case in a timely manner so that they can get a ruling before the Department of Education can act?
Well, that very concern we've raised with the judge in the Cato's case in the District of Kansas. And I think the judge was sensitive to that possibility. So we're prepared. We will obviously monitor the situation. Fortunately, this is a Supreme Court case, so it's very difficult for us to miss it. So we'll hear about it soon enough, and then we'll be able to file an emergency motion for what's called a temporary restraining order to ask the judge to put a halt on the program before the money can flow out, because it is more difficult to take the money back once it flows out. But at the same time, it's not like it's not like the government's going out and dropping out buckets of cash in people's front doors. Even if the government were able to move very quickly, it'd probably just be like a letter, sent out to people. And there could also be an injunction basically saying just send people a correction. We sent you a letter on Tuesday that you got $10,000. On Thursday, you get a second letter that says never mind. We're rethinking it, and that's certainly something that could be done.
Yeah, well, and the issues are fully briefed at this point, and we've asked for that relief. It's just the court has not really acted upon it. So I think we could very quickly, upon issuance of an unfavorable Supreme Court decision, get before our judge very quickly and say, remember that motion we filed back in whenever it was, November?
Yeah, November.
We really need you to rule on it immediately. And our papers made it clear even back then, because the way the other litigation was percolating, we were at risk at any moment that any of these injunctions would be set aside. So we were pretty much ready to pull the trigger on, really demanding that we need some answer.
Well, I think the federal government sort of did already what you're kind of describing, because they did start telling people apply for this, and then they stopped. It's like, oh, hey, sorry everybody, but you can't keep applying because it's held up in court. by mean people who don't want you to have money. But they did say, okay, we got to stop because this isn't court.
But I think they've already taken 20 million applications at the time they stopped.
Yeah, it got
so
flooded.
Theoretically, they could push a button and send out an email to all 20 million. I don't know how many of them are approved, but all, up to 20 million applicants, and tell them all, some of whom, I guess, will add many of these people who stand to get forgiveness work at our organization, who have standing loans. Some of my colleagues do.
It's important to remember they're not actually getting money.
Yeah.
They're not having to repay. So it's not like they would have to retract checks or something that are being sent to people.
Well, as I recall, and you may probably remember this better than me, the application was pretty light and was mostly an honor system.
Yeah.
Yes, it was basically, hey, tell us you want money and you have debt, and we will eventually check to see if you're lying to us. And if you're lying to us, then there could be trouble.
Yeah,
But
yeah.
it was basically, hey, flood us in. And I sort of felt like that was a strategy to make it politically unpalatable to have lawsuits, maybe to scare judges, I don't know. But it was in such a rush that you felt like they wanted people to feel like they were getting something, and then they would be even angrier if it was stopped.
Yeah, it was shortly before a midterm election, you might recall. Do we have other questions? Kara?
To what extent during the arguments yesterday did the point come up that Congress has at least kicked around the idea, or bills have been presented over time that would have addressed this? Did that play a role in the justices' questioning?
Yeah,
The one thing I do remember is the Solicitor General pushing back on that and saying, well, all that proposed legislation, that wasn't like what we've done here. So it's sufficiently different. You can't say that Congress specifically rejected what we've done here. So
Yeah, the Solicitor General of Nebraska certainly made that point, that I think Senator Warren had a legislation that ultimately was not passed. There were several other attempts that looked very similar. I mean, even the amounts was like $10,000 or $50,000. It was, with some income thresholds. And the Solicitor General of the United States made an interesting point, I thought, that in the ARPA, what is that, American Recovery Act of 2021, Congress said that loan forgiveness of any sort would not be taxed from 2021 to 2025. And she made the point that, well, this was really Congress opening the door for the Secretary to act and forgive some amount of loans. Although I think she maybe makes that point too strong or overinterprets that, because they could just simply be they were planning to say open the door to congressional action, because at that time there were bills in Congress forgiving loans that ultimately did not pass, and it opens the door maybe for lower the taxation for people who take advantage of other pre-existing forms of tax.
And the
relief.
administration, as it was, I guess, waiting for this report to tell them what they said was obvious, which is they could use the HEROES Act, they were undertaking a lot of additional forgiveness that was of smaller types and that was clearly in statute. So if you were going to a school that somebody found defrauded you, they made it easier to get that forgiven. They changed public service loan forgiveness, so it was easier to get that forgiven. So this was coupled with efforts by the administration separate from the HEROES Act and from cancellation, or this mass cancellation, to make it easier for particular subsets of borrowers under existing rules to have their loans forgiven. So it's equally plausible that they changed this taxation because they knew these other things were happening.
Yeah. Do we have time for one more? Looks like we're out of time. So on behalf of the New Civil Liberties Alliance, I want to thank you, panelists, and thank you for coming and listening online for this Luncheon Law program called Unforgivable Student Loan Forgiveness. And please be sure to join us for future programs. We got some great ones coming up. I think the dates are still being worked out, but we're going to be having one on ESG policies another one on state-sponsored censorship, and then unconstitutional regulations generally, like taking away your gas stoves. So, so thank you, and everyone have a great day. Thanks.